Good morning, everybody. This is Pastor Augustus Corbett and co-pastor Tony Corbett. How you doing, sweetheart?
I'm doing well. How are you doing?
I'm doing very well. All right, so this morning we're going to do something different in light of two events. First, this is the 4th of July, 2021. And this past week, we received from the U.S. Supreme Court an awful court opinion regarding voting rights. And when I put those two things together, this is a Sunday where we need to take special note of what is going on, and we need to educate you as well. So we're going to play a pre-recorded conversation that Tony and I had regarding the Voting Rights Act, where I took the time to explain this long 85-page opinion, again, having to do with the Voting Rights Act. And so, Tony, I'm looking forward to sharing this with the audience this morning.
Yes, I am too, because it is critical information that you are disseminating. So it's very consequential, this law that was just passed this past week.
Now, to set some context, Isaiah chapter 10 says, "Woe to those who make unjust laws, to those who issue oppressive decrees, to deprive the poor of their rights and withhold justice from the oppressed of my people, making widows their prey and robbing the fatherless. What will you do?" Now, the Lord is talking to those people who make those unjust laws. He says, "What will you do on the day of reckoning when disaster comes from afar? To whom will you run for help? Where will you leave your riches? Nothing will remain but to cringe among the captives or fall among the slain. Yet for all this, his anger is not turned away. His hand is still upraised." I just wonder if many of the things that America experiences, like $26 trillion in debt, a deadly pandemic, this or that always happening that causes some sort of human misery in this country. So while we appear to be, the wealthiest and most powerful country in the world, we have some serious problems here. And I just wonder if those problems are connected to the way this country treats minority people.
Yes, that's a very good question.
So we're going to, as African Americans, we're going to have to really fight back with what we see happening right now. You got the 4th of July, the day that our country celebrates its independence from Britain. But we got this awful court opinion the week before the 4th that affects our rights to vote as African Americans. And so when I juxtapose those two things, I don't have a celebratory spirit this morning. I think about the words of Frederick Douglass, who says, "What is the 4th of July to the Negro?" And the word Negro, that term was the vernacular of that day. Obviously, today it's more, it's acceptable to call us African Americans or Black Americans, not Negro. But the question that Frederick Douglass asked is still pertinent today. What is the 4th of July to the Negro? And he was asking that question during slavery. So he was asking, why should the African American celebrate the 4th of July, the day that the country gained its independence from Britain? Why should Negroes celebrate that day when they were still enslaved? And so, while we're not enslaved today, we still deal with a lot of oppressive laws, a lot of oppression, a lot of systemic racism, structural racism, institutionalized racism. And so until all badges and incidents, until the root and branch of racism is done away in this country, why should we celebrate the 4th of July? Why, a few days after the U.S. Supreme Court essentially disenfranchises us in many ways, why then should we be all happy and giddy about the 4th of July? As Frederick Douglass said, that is basically cruelty.
Yes, I think you said that very well. Now, we know since Frederick Douglass, we have made progress.
Yes,
We've made some sweet progress.
absolutely.
We have really come a long way, but we still have a long way to go
Yes,
because we're always striving to make this union a more perfect union.
yes,
It has not reached perfection yet. And God, throughout the Bible, He demands justice. He said, demand justice, seek justice. He said in Amos, I want justice and I want oceans of justice.
amen.
That's one translation.
Yes,
So this is not a political concept.
mm-mm.
Justice is from the heart of God. In fact, He said His throne consists of righteousness and justice.
Yes,
So we are in the book.
amen. We're in the Bible when we demand justice. And so, again, we're going to play a special pre recorded conversation that Tony and I had where I explained what this court opinion means for the African American community and for this country. And actually, the court opinion will not just affect African Americans, it will affect minorities, period. And it will affect a good number of poor whites. But no question, the biggest impact will be on the African American community, no question. And the folks who wrote the laws across the state, across this country, to disenfranchise folks were hoping to get this type of an opinion. And so they got the opinion that they wanted. So we're going to get into that conversation. Now, before we play that message, I want to remind you that there's another area, another system in this country that is also replete with systemic racism, and that is the education system. I used to be a high school chemistry teacher, and it was just an eye-opening experience for me. And then as I was becoming a lawyer while in law school, I researched and wrote this book. And it is filled with lots of studies and research. It's not just my opinions, but it is a researched book full of data that will show you that the school system, the public school system, is extremely unfair to African American children, especially African American males. So get a copy of the book. You can get it at Amazon.com, or you can get it from our website at educationinjustice.com. Both places you can get a copy of the book. It is $14.99, I believe. If you buy more than one, we're happy to give you a discount depending on how many you get. And I bring it up because it's all connected. Voting rights, connected with education rights, connected with healthcare rights, connected with corporate rights. It's all connected, and dare I say, it kind of all flows from our ability to vote.
Yes,
right?
representation matters.
Representation.
Yes.
What's the old saying? Elections have consequences.
Right.
That is the reason why we got this off opinion, because there was an election in 2016. And who was elected? Donald Trump. What did he do? He put a bunch of conservative, deeply right-wing conservative judges on the court. And it was those 6 Supreme Court justices that gave us this awful voting rights case. And so that is just one example of how much elections have consequences. And so we got to respond. But before we respond, we got to be educated.
Right.
And that's what this pre-recorded message should do. All right? So if there's nothing else to say, we're going to get into that message. Hello, everybody. This is Attorney Augustus Corbett, and with me I have my lovely wife, Antonia Corbett, and we're going to talk to you today a little bit about the Voting Rights Act, and we're going to share with you why we are so depressed at this last case that was handed down by the United States Supreme Court. Before we do, I want to welcome you to the Social Justice Manifesto podcast. And once again, I have with me today my lovely wife, Antonia Corbett. How you doing, sweetheart?
I'm doing well, but like you, I really hate this opinion that came down. But yeah, I'm ready to get into this to talk about it and discuss it and get your insight.
Well, yes, we're going to get into it. It is a very depressing case, quite frankly. Um, I entitled this particular video, Why the Voting Rights Act is Dead, essentially. So we'll just, right off the top, just get straight to it. The Voting Rights Act of 1965, it was passed in 1965 and signed into law by Lyndon B. Johnson, is essentially a dead piece of legislation.
Wow, that is just so incredibly hard to believe in the 21st century in 2021. Wow, that they are able to turn back the hands of time is just incredible. So yeah, I'm ready to get into this as well.
Well, as far as voting is concerned, we're moving closer back to the Jim Crow era. And I mean, it is what it is. I'm not going to hold back. I'm going to speak very clear about this because we're in dangerous, serious territory where our voting rights are concerned. When I say our, obviously I'm talking about us African Americans. And if our voting rights are in jeopardy, so much other stuff flows from our ability to pick politicians who represent our interests.
Right, right. You are so right. Representation matters. Yes, I totally agree with
Yes.
that.
And what's the old saying? Elections have consequences. And that is the reason why the Voting Rights Act is essentially dead because we saw the election of Donald Trump and he put three very deeply conservative judges on the court, and they had the opportunity to finish gutting the Voting Rights Act, and that is exactly what they did. The Voting Rights Act was already hanging on a thread. Well, they cut that thread off basically. So let's get into this. I invited you to be on with me today because I didn't want to just sit and do a monologue about this important development. I wanted you to come on and kind of guide this discussion. And, basically, I guess for lack of a better word, we're going to do an interview and I'm going to try my best to explain why the Voting Rights Act is essentially dead and what that could mean for African American voters.
Right.
So I give it over to you.
Okay. Well, thank you so much for having me on to, um, I guess, solicit information from you and get your insight, your legal analysis with you being a practicing attorney here in the state of Texas. So we're going to get right on into this. From what I understand, it seems as if in this ruling it was section 2 that was addressed. So can you please tell us what exactly is section 2 of the Voting Rights Act?
Sure. Um, Before I tell you what Section 2 is, let me explain to you about two other sections of the Voting Rights Act that are equally, if not more important. And those
Okay.
sections are Section 4 and Section 5. Now, Section 5 essentially outline all of the bad things that racists had been doing to keep African Americans from voting. Things like poll taxes, literacy tests, grandfather clauses, and so many other awful things to keep us from being able to vote. That all those things were outlined and are outlined in Section 5. Section 5 is still a part of the Voting Rights Act. But Section 5 worked with Section 4. Section 4 required certain states to get pre-clearance, to get approval before they were able to change their voting rights laws. Now, the Voting Rights Act came about as a result of the 15th Amendment. So during Reconstruction, of course, the 13th Amendment abolished slavery. The 14th Amendment, among other things, gave us citizenship, due process rights, equal protection rights. And the 15th Amendment gave us the right to vote. When I say us, I'm talking about the newly freed, enslaved people, our ancestors. So the 13th Amendment abolished slavery. In fact, we just finished celebrating June 19th, the day that commemorates when Texans here found out that slavery had been abolished, and that has kind of now become an important day in African American and, dare I say, American history. In fact, it's now a national holiday. But then the 14th Amendment also empowered us with certain rights, due process rights, equal protection rights, and citizenship rights. And then the 15th Amendment gave us the right to vote. But here's the thing. When the 15th Amendment was added to the Constitution, it still took another 100 years before the 15th Amendment really had any teeth. And that teeth came about with the passage of the Voting Rights Act.
Wow. So it took all the way up until 1965?
That's right. That's right.
Okay.
And because although the 15th Amendment had been added to the Constitution, whites were still interfering with our ability to vote. So we had an amendment to the Constitution, but there was really no real way to enforce that right. And so during the Civil Rights Movement, Congress enacted the Voting Rights Act so that there would be teeth, there would be strength and power to protect and enforce our right to vote. And so that is the purpose of the Voting Rights Act of 1965. Now, you heard me just talk about sections 4 and 5. Well, section 5, again, outlawed all the things that racists had been doing to take away our right to vote. So section 5 made a list of all those things. Section 4, determined which, it had a formula that determined which states, which jurisdictions section 5 applied to. Okay? Because certain states, certain jurisdictions were notorious, many of them Southern, but not all of them, were notorious about implementing, these tactics to keep us from voting. But the problem is in 2013, I think June 25th, I believe, I could be wrong about that, 2013.
No, they said I heard one of the co-founders of Black Voters Matter said they just celebrated that the 2013, the Shelby v. Holder
Yes,
law. So yeah,
that's
you're
right.
right. It was this month.
Right. Now, I wouldn't call it celebrated. We didn't celebrate it. We
I mean, not
commemorated it.
celebrated. Yeah, that's not the right word.
We
I guess
commemorate
remembrance of what happened.
precisely because the Shelby County versus Holder case was the first case think of it this way: Section 4 and 5, consider them to be one leg together, one leg of a stool. Okay?
Okay.
And think of Section 2 to be the other leg. Well, that's a bad example because you need three legs. So, yeah, think of a three legged stool: Section 5, Section 4, Section 2.
Okay.
And the Shelby County versus Holder case pretty much knocked out Section 4. And without Section 4, Section 5 had nothing to apply to. So the only thing that was left of the Voting Rights Act is Section 2. Okay?
Okay.
Now, again, Section 4 and Section 5 required certain states to get pre-clearance or pre-approval from the Justice Department before they made any changes to their voting laws.
Okay, so stop right there for 1 minute.
Okay?
So with the way that we see the states are changing their laws now, if certain states, if 2013 had not happened with Shelby v. Holder, then certain states, if they wanted to change their laws today, they would have to have gone and gotten clearance by the Department of Justice. Is that what you're saying?
That's exactly what I'm saying.
But
That's exactly what I'm
because
saying.
But because in 2013 the Supreme Court handed down this ruling about Shelby v. Holder, these states now can do and change these voting laws without any pre-approval.
That's
That
right.
was the effect of that passing of that law in 2013, right?
That's exactly right.
Okay.
So after the court handed down the Shelby County versus Holder case, it was Shelby County, Alabama, that sued Eric Holder, who was at that time the Attorney General.
Okay.
So the case just became known as Shelby County versus Holder. And basically, Shelby County argued that the Section 4 and Section 5 of the Voting Rights Act were really no longer needed because African Americans had become so strong and powerful in their voting rights, having elected and reelected the first African American president and having elected many other politicians, members of Congress, etc., that there was no point in requiring southern states anymore to have to get pre-clearance and pre-approval. Well, unfortunately, the U.S. Supreme Court bought that argument and basically gutted Section 4 of the Voting Rights Act. Now,
Okay.
what the court said was, Congress, the formula in Section 4 is no longer a good formula. So we need you, if you want to see the Voting Rights Act restored, we need you to come up with a better formula that is more in alignment with today's circumstances. Because this is not Jim Crow, this is not the 50s and 60s. Black Americans are now voting in large numbers. So you need to come up with the formula that doesn't continue to penalize these states that were once notorious in their voting laws.
Okay.
So that was 2013. Congress has not come up with the new formula. They have now, and they've been trying to get it passed, but they've not been able to get it through. Right now, it's called the John Lewis Voters, I think, Reestablishment.
Advancement Act.
Okay,
I think
thank
it's
you.
advancement.
All right, the John Lewis Voters Advancement Act, which is designed to restore Section 4 of the Voting Rights Act, okay, with the new formula
Okay.
that would satisfy the U.S. Supreme Court. But we know they've not been able to get that through Congress. They've been able to get it approved in the House, but they've not been able to get it through a conservative Republican 50 members of the U.S. Senate, okay, because of the filibuster rule. We'll come back to that later. So Congress finally got half of the Congress to approve the John Lewis Voter Advancement Act, but it's held up now in the Senate. And while it was being held up, another case, couple of cases, but one principal case came out of Arizona that was going to deal with the last remaining section of the Voting Rights Act that still could protect, to give some protection to minority voters, and that is Section 2. All right, so when Section 4 and Section 5 were rendered basically ineffective, that still left Section 2. Section 2 does not require pre-approval like Section 4. Okay,
Okay.
that was the real strength of Section 4. It required that the Justice Department sign off on any voting law of those particular states. But that's gone. That was gone after 2013. So then the only way to challenge a state's voting laws after 2013 was with Section 2.
Okay, so that helps. Okay, that helps me. So after
Okay?
2013, what remained in place where people could challenge discriminatory practices in regards to voting rights, you're saying was Section 2 of the Voting Rights Act of 1965.
That's right.
Okay. And one thing else, if you could just, I mean, when you were talking, I think if the audience would just know all of this was to protect the black vote. I
That's
mean,
right.
the 15th Amendment was came about because black voters needed protection. Because nowadays I think they feel like we're so removed that we don't need protection, but that was the whole point. We needed the protection, and still, in my opinion, can we still need some protection
Well,
because
that's it's obvious that we still need protection because once Section 4 from the Voting Rights Act was basically gutted, immediately Texas, North Carolina, and other states immediately started implementing restrictive voting rights laws
right, right,
because Section 4 no longer required them to get pre-approval. So, and I'm talking immediately, the next day, the very next day after the voting right, after Section 4, after Scotus got rid of Section 4, the next day, the
wow,
state of Texas came out with a restrictive voting law, and other states have followed. So now we see states, I don't have the map, but Texas, um, Georgia,
Georgia, yeah,
Florida, I
hmm,
believe,
yeah,
and other states are matriculating restrictive voting laws through their, in fact, I believe it's like 40 something states. Okay.
right,
And all of that happened after the Shelby County versus Holder case when Section 4 was gone. And
okay,
the only way to challenge those states was under Section 2. So people who were trying to disenfranchise us knew that if they could get their hands on Section 2, that would completely gut the Voting Rights Act. And that is what happened with this very last case that came out, I think it was Thursday.
okay, okay. So there's some good
Okay?
background. So
Okay?
yeah, thanks a lot for that backdrop to all of this. So there was a case that matriculated up to the Supreme Court of the United States. I believe you're going to say it came from Arizona,
From
right?
Arizona,
And
Bronovich,
so,
Bronovich, Bronovich versus the Democratic National Convention, Bronovich versus the DNC, basically.
okay, okay. So that case reached the Supreme Court and they ruled on it right before they went on their vacation break last week. So now, does that Is that all of the backdrop you want to give to us, and then get into the ruling?
Well, I just want to make sure folks understand that the point of this case that was just handed down, the question was whether or not two Arizona laws, and there were two cases and they consolidated them, but we're focusing on the Arizona case, the Brownovich case. The question was, did the two laws that Arizona enacted, voting laws, did those laws violate Section 2?
Okay.
That was the question.
Okay.
All right.
Good. Mm-hmm.
And here's the thing. Arizona was able to pass the laws first, and then it was litigated. Had Section 4 been in place, in fact, these laws, this is a very important point, because Arizona tried to enact these laws before the Shelby County case, and the Justice Department said no.
Okay. Yeah, that was the point I was asking before. If the before 2013, they would have had to have gotten pre-clearance, and you were saying Arizona tried to get pre-clearance before 2013,
That's
but
right.
now after post 2013 Shelby County versus Holder, they did not have to get pre-clearance, and so they were able to enact these two laws this year.
That's exactly right. So that is
Okay.
the procedural history of this case. That is the background of
Okay.
this case.
Okay. So since this case is talking about
And
Section 2,
let me just
okay,
give one more little piece of information, a little procedure history for the lawyers, the attorneys who may watch this video. So
okay,
the case in these federal cases, they typically start out with a local federal court, and that is what happened. A local federal court heard the evidence in this case and they did extensive hearing. A lot of evidence was introduced, and that federal judge found that he ruled that he or she, I'm not sure if it was a he or she, but that federal judge ruled that those two laws did not violate Section 2. Okay?
okay. So
And
what we saying? Oh, go on. I'm sorry. Go on.
that opinion, that his ruling was appealed to the Ninth Circuit. Okay? And initially, the Ninth Circuit upheld the ruling of the lower court judge.
Okay.
But then the litigants requested in what we call an en banc hearing. And that is, we want to let like the full court or a panel of the court look over the opinion that was handed down by the Court of Appeals, the Ninth Court of Appeals, Ninth Circuit Court of Appeals. So they had originally agreed with the lower court, but then the litigants said, no, we would like for an en banc hearing to take place. And it was that en banc hearing where they said, no, these laws do violate Section 2.
Oh, okay. So then there was a little uh conflict there then,
That's right.
right? Okay.
That's right. And once that Ninth Circuit en banc panel found that the Arizona laws, in fact, did violate Section 2, then it was appealed to the U.S. Supreme Court, and the U.S. Supreme Court issued a writ of certiorari basically saying, yes, we will hear this case. You know, the U.S.
Okay.
Supreme Court doesn't hear a lot of cases each year. They tend to take cases that have national import, and certainly this one was. In fact, given the fact that there are now 6 conservatives on the court, they probably could not wait to get their hands on this case so that they could finish doing violence to the Voting Rights Act.
Okay. So that's how it got there.
Right.
Okay, very good information. Thank you so much for that.
Mm-hmm.
So it reached the Supreme Court after the lower court and the appellate court
Mm-hmm.
said that the Arizona law did not violate Section 2 of the Voting Rights Act of 1965. But then when I, I guess you said the legal term is en banc or in however you
An
said, the
en
full
banc, yeah,
panel,
an en banc, yep, panel
en
of
banc
appellate
panel.
judges overruled their colleagues and said, yes, it does violate Section 2.
So then there was a contradiction in the opinions. So then it went all the way up to the Supreme Court. That was the next level, I guess it could go. And there they agreed with the lower court and the appellate court saying it does not violate Section 2 of the
That's
Voting
right.
Rights Act.
Yes.
Okay. So that helped me. I hope our audience, asking the questions, you all, in the comment section if you have any. But yeah, that okay, that helped. So now they had it, they reviewed it, um, and they handed down the opinion last week. So
Yes.
now you ready to take up what actually they said?
Yes. The opinion is 95 pages. Okay. It's a relatively long opinion.
Okay.
I've read every word of it. And the reason the reason it is so long is because there are 2 parts to it. There's the majority opinion, and then there's the dissenting opinion. The
Okay.
majority, and by the way, again, you got 9 justices, 6 of them are conservative. And look, this politics, influences this stuff. All right. I mean,
Oh
there's
yes.
just no way to look at it, other way to look at it. Because, for example, the Ninth Circuit, back to the Ninth Circuit a second, it is known to be somewhat of a liberal court. It's out in California, and it has a liberal reputation. I think some people at one time would consider it to be the most liberal appeals court, circuit appeals court in the country. And conservatives started focusing their attention on, by that I mean, conservatives started trying to get more judges on the Ninth Circuit so that it would not be so liberal. And
Well, now with you saying that, I'm seeing just how important the judges that are appointed, how important they are because they're making all these critical rulings and
they are,
consequential rulings that affect day-to-day living.
in our nation, the judges are very important because, again, we are a country of laws, not of men. Okay? And so that is one reason why, despite all his issues, having been impeached twice and all the other issues that Trump had, he was so popular amongst white conservatives because he got several hundred judges approved by Congress.
Yes.
Okay?
Yes.
Three
Mhm.
of which three of which help bring this case about. All right?
Right.
And let me just briefly mention the 9 justices on the court. I don't have a picture of them. I got a picture of the 6 conservatives. But there's Chief Justice John Roberts. There was Justice Clarence Thomas. There is Justice Neil Gorsuch, Brett Kavanaugh, and Amy Coney Barrett. Those are the conservatives, and Samuel Alito. And the liberals are Stephen Breyer, Alina Kagan, who wrote the dissenting opinion, and Justice Sotomayor. So those are the 9 justices, 6 conservative, 3 liberal. Now let me see if I can bring up a picture of these 6 conservative judges. There they are. Okay, Justice Sam Alito, Justice Clarence Thomas, Justice Brett Kavanaugh, Justice Amy Coney Barrett, Justice Gorsuch, and Chief Justice Roberts. All 6 of them made up the majority of this case.
Okay, let me ask you one question. I had heard that Chief Justice Roberts had been working really on trying to, I guess, roll back voting rights since the Reagan administration.
That's right.
Is that true?
That is very true. Chief Justice John Roberts was a part of the Reagan administration. I can remember, I almost can remember his appointment. He was a young lawyer back then, so he cut his teeth as a lawyer fighting to dismantle a lot of the civil rights laws, including, and maybe most especially, the Voting Rights Act. So it is that type of judge with that sort of ideology that is now Chief Justice of the U.S. Supreme Court.
Wow. Wow.
And
Wow. Wow.
yes, and he has he has 5 colleagues. They may disagree on the Affordable Care Act and may disagree on some other stuff, but when it comes to race, they
Right.
are in close agreement, including
That's,
Justice Clarence Thomas.
yes. That's the tie that binds them. Race. I've noticed that just being married to you, with you being a lawyer and you keeping up with this and abreast, you have the television on, you read books, and I see all of these books around here. That, yeah, I now know how it seems as if that is the one thing they do agree upon, and that's when it comes to civil rights, wanting to dismantle the progress and the gains that we have made as a community of people. So yeah.
Yeah, I mean, when you think about the ruling in a recent transvestite case, it was one of those conservatives who sided with the LGBTQ community, Judge Neil Gorsuch. He basically wrote the opinion that said that you couldn't discriminate against transsexual people. And some of his conservative colleagues strongly disagree with him. But when it comes to race, the issue of race, they strongly agree with one another on that issue. All right?
Yes. Okay.
Okay. Now, so back to Section 2. I think you had initially asked me 15
Yes.
minutes ago
Going
about
back to my
Section 2.
question. Yes.
Exactly. So, so I think a good thing to do is to read Section 2. All right.
Okay.
I'm gonna try and keep this simple, Tony, because this is complicated stuff. Okay, this
Right.
is really complicated. I'm gonna try and keep it simple. Get into as much details as possible without it becoming too dense, and without losing people.
Right.
So I'm gonna put a PowerPoint on the screen, and this is subsection A of Section 2 of the Voting Rights Act of 1965. And I want to read it, and then we'll look at subsection B of Section 2 of the Voting Rights Act. So subsection A says, no voting qualification or prerequisite to voting or standard, practice, or procedure shall be imposed or applied by any state or political subdivision in a manner which results in. Now I want you to pay close attention to the words which results in, a denial or an abridgment of the right of any citizen of the United States to vote on account of race or color or in contravention of the guarantees set forth in section 10303 F2 of this title as provided in subsection B. Again, the principal part of this subsection are the words which results in. I'll come back and explain why in a moment. All right, now, next, subsection B. It says a violation of subsection A is established if, based on the totality of circumstances, it is shown that the political processes leading to nomination or election in the state or political subdivision are not, quote, equally open to participation by members of a class of citizens protected by subsection A, which we just read, in that its members have less opportunity than other members of the electorate to participate in the political process and to elect representatives of their choice. Now that's subsection B. So subsection A basically said that states and their political subdivisions cannot enact laws, qualifications, or prerequisites to voting that imposes, some requirement in a manner that results in a denial or abridgment of the right of any citizen to vote on the account of race or color. Now, I heavily emphasized the words which result in, and here's why. Legally, they are significant words. What conservatives tried to do when the Voting Rights Act of 1965 was debated by Congress some years ago, they tried to impose, based on several Supreme Court cases, they tried to impose a standard based on intent. Intent. In other words, they wanted language in subsection A that would have read, let me go back to it, instead of saying which results in, they wanted it to say in a manner based on intent to deny or abridge the right of any citizen on the basis of race to vote. So they wanted section 2 to be based on a litigant having to prove that the state intended for their new voting law, whatever it is, interfere with a black person's right to vote, or a Hispanic person, or a Native American, or an Asian, okay? That was what they wanted. They wanted this to be based on intent. Why? Because it's hard to prove a person's intent.
Right.
It is really difficult to prove that someone intended to do something unless their actions are so very clear. Well, these folks are very good at hiding their intent. They can introduce or enact laws that are very subtle and makes it nearly impossible to prove intent. So fortunately, Congress did not fall for that trick, because there were people in Congress, African Americans and others, who knew not to fall for that trick. And they debated and debated and debated until they agreed on this language, which results in a denial. So, in other words, regardless of the intent of the law, the question is, does it result in the abridgment or denial of minorities' right to vote? That's the question. Does it result in? So when you look back at an election, can you show that because of some laws, African Americans, Asian Americans, Hispanic Americans, Native Americans were kept from the polls or they couldn't vote? Are you able to just show that that was the result of the law? Not that that was the intent of the lawmakers. We don't care about that. We don't care about their intent. We care about what was the result of the law. Okay?
So then, are you now talking about showing the disparate impact
Yes.
of the law? Because
Yes,
that was
that's
one of my
enough.
questions. What is disparate impact?
All
Is
right.
that
So
kind of what subsection A of um, section 2? Is that what that was kind of referring to? That results in?
that's right. Those
Okay.
two legal terms are very much connected and related.
Okay.
Disparate impact means, does the impact of the law have a disparate result or impact on a particular group of people? In other words, does it affect one group of people more than it does another group of people? Is the result or the impact disproportionately affecting one group rather than the other group? So when
Right.
you think of the word disparate, think of the word disproportionate. Think of the
Right.
word out of proportion. So if, let's say, a county has 10% African Americans, but a law was passed that kept 30% of the African Americans from being able to vote. Okay? No one
Mm-hmm.
else was impacted that way. It was only African Americans who were impacted to that degree. Let's say
Right.
the same law had impacted and kept 1% of white voters away from the polls, but 30% of black voters. That is a disparate impact. That is the kind of result that Section 2 was intended to stop, to prohibit.
Okay. Okay. I'm with you.
Are you with me?
Mm-hmm.
Okay. So the subsection B, if we go back there, and again, tell me if this is getting too dense. Subsection B, again, a violation of subsection A is established if based on the totality of the circumstances. So what has to be looked at is all the circumstances surrounding the law and the application of the law and how it affected folks. So in order for a court to be able to determine if Section 2 was violated, they got to look at a host of things, a myriad of different factors and circumstances. That's what subsection B requires. And once they look at those totality of circumstances, the question becomes, did this law, based on all the circumstances that are available, did this law result in the election process not being equally open to participation by members of a particular class, members of a protected class? You see, that was the
Mm-hmm.
question.
Right.
Based on the totality of circumstances, is voting equally open to everyone, including members of a protected class? If so,
Okay.
Section 2 was violated.
Okay.
And we don't care what the intent of the legislatures were. That's not important. What's important is what was the result. And in
Right.
order to determine whether those results were violative of Section 2, the judge would have to look at the totality of circumstances to determine was the voting process equally open to everyone, most especially protected members of a protected class, minorities, basically.
Okay. So I think we have you have really drilled down on section 2. You showed us section 2, subsection A and subsection B. So I think in this, for the sake of time, I would want to move on now to actually the majority opinion and the minority opinion in this Voting Rights Act.
Okay. All
If you
right.
can just tell us what I believe you said Justice Alito wrote the majority opinion, what he said as to whether or not he agrees to uphold the Arizona laws or not. And then
Okay.
Justice Kagan wrote the minority.
Okay. She wrote the dissenting opinion. All right.
Right. I'm
So,
sorry, the descending. Okay.
yeah,
Yeah, thank you. The descending, not minority, but I mean, they were
dissenting.
minority, but dissenting,
Dissenting. Yeah.
dissenting, yeah,
Yes.
opinion.
Okay. So now, so Arizona passed two laws, and I got to paraphrase all this because you're right. In the interest of time, and we don't want to get too dense here.
Right.
So Arizona passed two laws. One law basically would cast out folks' votes if they voted in the wrong precinct. Okay.
Okay.
The other law would make it. The other law made it a felon for someone to end up with someone else's ballots. Okay.
Mm-hmm.
So let's say someone got an absentee ballot from the state and they filled that ballot out and gave it to a neighbor because, doing early voting, said, hey, look, John, take this ballot with you down to, the polling place and give him my
Mm-hmm.
ballot. Okay.
Right.
And let's say John was not a family member, John was not one of the election officials, so on. John could be charged with a felony.
Right.
All right.
Right.
So
Mm-hmm.
that was one law that Arizona passed. Again, the
And let
other
me
law,
and let me just say this: when I was looking at this in Arizona, the minority population that probably is going to be disproportionately impacted would be the Native American, because I read where only 26% of Native Americans live on a postal route.
that's right.
So that means a lot of times they would do this. Okay, well, let's go around and collect these absentee ballots and take it to wherever they need to go. Well, with this law is going to cut that out. So that's going to disproportionately affect Native American, the population of the Native Americans in Arizona. Because only,
That's
I mean, think about that, only 26% live where they actually get mail from the Postal Service.
yes. So that is a good point. I'm gonna come back to it in just a second.
Okay.
That's a very good point. Um, so I want folks to understand what these two laws did because I want people to connect these kind of voting, restrictive voting laws to the laws that were passed in Georgia, to the laws
Okay.
that are passed in other states. Just little subtle
Right.
things, right?
Right.
What's wrong with someone being required to vote in the same in the right precinct? Well, there's a lot wrong with that because, you know, you and I have at times voted on our way home from work in a
Mm-hmm.
precinct that we were not registered to vote in.
Right.
And
And
out of
remember we and remember you and I, we now live in a city where you have two different counties within that one city.
That's right.
So you could go and accidentally be on the other side of, on in another county voting even though you in the city you live in.
Yes. And so when you take so if you under Arizona law, if you're supposed to vote in precinct 3, but out of convenience you wanted to vote in precinct 5, your vote will not count. And why? Because of this fake, false notion of voter fraud.
Right.
Okay? That's what the GOP uses to justify all of this disenfranchisement. And we know that there is not a big voter fraud issue in this country. We have a sound election system. Donald Trump basically undermined our election system and our democratic process here by telling this big lie that the election was stolen from him. That is a huge lie. And again, it undermines the integrity of our voting system. So there is no big voter fraud issue for the GOP to justify their disenfranchisement laws, but that's what they use. And again, it really took on, real strong meaning because of Trump's lies about him having lost the election because of fraud. I mean, even Republican judges, Republican governors, Republican secretaries of state all said you're lying. That did not happen. Yet he continued to push that lie. And the politicians, the GOP and the state houses and Congress used that lie to get a lot of these laws passed. And lo and behold, guess where that lie showed up? It showed up in this court opinion.
Wow.
And dare I not, as a licensed attorney, call a member of the highest court in the land a liar. I am not doing that. Okay? I'm not calling Justice Sam Alito a liar. He is, by all measures, an honorable man. I just disagree strongly with this opinion. Okay? And I believe the numbers back me up when I say that there is not a huge voter fraud issue in this country. Our election system is strong. This is not a banana republic. This is not a third world nation. We have a solid voting system. And so there was no need, or it wasn't justified, to base disenfranchisement law in this opinion. And Justice Alito mentioned voter fraud several times as a state interest that could be used to overcome a Section 2 complaint. Okay?
Okay.
Now, so how did Justice Alito and the majority get there? They left Section 2 in place, but they listed these, we talked about the totality of circumstances. So what he did was he wrote out a number of factors that a judge should look at that would or could justify disenfranchisement laws. So he made a list of things, one of which I want to mention, because it's these things that lawyers for the GOP will look at and argue that their state's voter laws are constitutional. They'll just look at this opinion and just try to make sure that they, are based on these factors. In other words, Justice Alito wrote an opinion that provides a roadmap for voter disenfranchisement. Okay?
Wow.
It provides a roadmap. It shows states exactly how to disenfranchise minority voters under the law, under what we call race-neutral laws. Justice Elena Kagan did a brilliant job in the dissent, showing how this opinion, even based on neutral laws, when I say neutral, race-neutral laws, how this opinion still will result in massive minority voter disenfranchisement. Now, one of the things that Justice Alito said, and he said so much, again, this is a 85-page opinion. He says here just one thing. First, he said, here are one of the factors that you can look at. First, the size of the burden imposed by a challenge voting rule is highly relevant. Now, let me explain what that means. Again, the size of the burden imposed by a challenge voting rule is highly relevant. So he said there that if a voting rule, if a voting law imposes a burden, the question becomes, how big is that burden? How big is that burden? Is it really burdensome, or is it a little burdensome? If it's a little burdensome, then it's okay. And Justice Kagan pointed out powerfully, a little burdensome for some people is really burdensome, whereas it may not be as burdensome for another group of people. And as you pointed out, let me go back to your bringing up the fact that Native Americans in the state of Arizona, for example, a lot of them do not have access to post offices, okay, or postmen, all right?
Right.
So their ballots, if all the polling stations are, the ballot boxes are at post offices, then you're going to eliminate a lot of Native American voters. Whereas that wouldn't have as bigger impact on white voters that have all kinds of post offices and postmen and women, coming to their houses or within sometimes walking distance or driving distance from where they live. You see? And that is the very thing that Section 2 talked about when it says, which results in. Forget this factor, how big the burden is. If there is any burden that results in one group of people not having equal openness to vote, then it is a violation of Section 2.
Right.
But now it's not a violation of Section 2 as long as it's a small burden.
Wow. So let me ask you this. In reading that 95-page opinion, 85-page opinion, are they now saying you have to prove intent if you want to challenge any, if you make any allegations of racially discriminatory practices regarding voting rights?
No, they did not and cannot. The judges cannot or should not, from their bench, start replacing words in Section 2. Okay, that's for Congress. So the language of Section 2 still is the language of Section 2. So it's a results test, not an intent test.
Oh, okay. Okay, good. Because I was thinking that they had shifted and had actually, said that now you have to show intent. Well, then how is this going to make it harder? Is this going to make it harder to file lawsuits? Would be one question I have.
Well, Section 2 is still in place. But by the time Justice Alito listed all of these factors, the results test almost kind of becomes an intent test.
Okay.
To go back to, yeah. I mean, it just makes it undermines the result test.
Okay.
Because again, think about it. Think about how onerous it is to say that a little burden is okay. Right. A little burden for someone who's healthy. Let's say you got two people. One is a healthy, strong, strapping young man, and the other one is a little old lady.
Right.
And you say to both of them, in order for you to get this water, you got to um, travel a mile to get it. Well, for the young, strapping, healthy young man, that ain't no problem. He could walk that in 5 minutes. But this old woman, she may not be able to get there.
Right.
But the court says, well, if that's deemed a little burden, it's okay.
So just because they are not taking into account all the different ways this can impact really a group of people who tend to be poor or living in rural areas or don't have access to some of the resources that people who live in the city perhaps have, or people who live in the suburbs, they're not taking into consideration that.
That's right. Justice Kagan points that out. She says the majority does not take in account the facts on the ground.
Okay.
Okay? They don't consider what real Arizonians are facing. And back to the point that you mentioned about Native Americans not having access to post offices. She wrote in her dissent, only 18% of Native voters in rural counties receive home mail delivery, compared to 86% of white voters living in those counties.
Mm-hmm.
You follow me?
Yes. Mm-hmm.
For that reason, an unusually high rate of Native Americans used to return their early ballots with the assistance of third parties.
Right.
So
And didn't you
now,
say
so,
and didn't you say that law now would make third parties collecting those ballots for those people, they would be charged with a crime, a felony?
a felony offense. There are exceptions. If it's a family member, that's okay. If it's like a voting official, that's okay. But let's say it was a neighbor, a friend, a coworker, okay, who doesn't fit in any of those narrow exceptions, that
Mm-hmm.
person could be charged with a felony and possibly even the voter, him or herself. I mean, that is for people who must rely on others to get their ballots to the box because they don't have access to post offices. That will have a huge impact on Arizona elections.
Right. And
That's the
then
point.
to extrapolate, I know this law was pertaining to Arizona, but as these other states begin to enact these restrictive voting rights laws, it's going to impact blacks, Latinx, um, you know, um, other minorities, poor people, you know, it's going to have the same impact because they're going to see, well, what can we do that can have a negative impact on this black person getting to the polls to vote. And we see that they have began to do that down in Georgia. So let me ask you this.
Well,
Um,
one more factor.
okay,
There are like five of them. We can't go over five, but one or two. Let me do another
okay,
one. These are the factors that Justice Alito said that would have to be taken in consideration when considering whether or not Section 2 was violated. Here's another one. The size of any disparities in a rule's impact on members of a different racial or ethnic group is also an important factor to consider. So you asked earlier about disparate impact, and I hope that I explained that well. It's when a law affects one group more than another group,
right.
right? So
Mm-hmm.
Justice Alito says, well, even if there's a disparate impact, it's okay as long as it's not too big.
Wow.
Do you see how essentially they have just gutted the meaning of Section 2 by adding these little caveats. Okay?
Yes. Yes, I
The,
see it.
the first one that I talked about was, well, as long as the burden is not too big. Because after all, it is always a little burdensome to vote. I mean, you have to stop on your way to work or on your way from work. You have to get out your car and walk into the polling station. So there is some burden to voting. Well, yeah, but if you add to that you now got to drive 2 hours, okay,
Mm-hmm.
or and then the disparity. That turns subsection A of section 2 of the Voting Rights Act on its head, because subsection A we read implements the results tests,
Right.
not on how big the disparity is. If it results in someone not having an equal opportunity to vote, no matter how big or how small, no matter how small it is, that is a violation of section 2. But not under this language. And so legislatures in these conservative states are salivating over this opinion, because now they just need to just sit down and just figure out ways to make it subtle, come up with arguments where the disparity is
Mm-hmm.
not that big, come up with arguments and strategies where the burden is not that large, and if so, regardless of what section 2 says, they can still get these laws passed.
Right.
Okay, like getting an ID. All right. So like here in Texas, you got to have either a state ID or a driver's license. I don't know the exact requirements, but I think those are two. I think you can even have a fishing license. But
A
that's
gun
it.
license in some states, something like a gun license.
Right. So license that most whites have,
Right.
but a whole lot of minorities don't have a driver's license or state ID. And I came to realize that, Tony, you remember I represented this young man, about 19 years old, young man. I represented him. He got himself in a little trouble. And we were trying to help him get on his feet. And in the process of trying to help him get on his feet, we had to help him find a job.
Mm-hmm.
Okay. These were the things that the prosecutor was requiring to work with this young man and try to keep all this off his record. And rightfully so. The young man needed a job. Okay.
Right.
And so we took him to look for jobs. Well, he told us, I can't really look for a job because I don't have any ID, and they all asked me for my ID.
Right.
So then we had to take him to the DMV on a couple of occasions, which was like 30 miles from his house.
Mm-hmm.
We had to take him twice to get a state ID. And that was difficult because just given his circumstances at home, he couldn't, it was initially, he didn't have like a birth certificate. He had to get his hands
Right.
on his birth certificate and all of that so that he could go back to the DMV 30 miles away from home so that he could try again to get his state ID.
Right. And that's what I want to stop you there. That's where some people, um, I guess, don't take into account where some folks are in this life journey. Some people just cannot easily get their hands on the documents that they need in order to even go get a picture ID. You know,
Exactly.
if
Exactly.
people have moved a lot of times, I'm a social worker, so there are many families who move several times during the year. They may move 10 times. Things
Yes.
get lost, documents get lost. and you have to have documents in order to even go and get a photo ID if a state issued or your driver's license.
Exactly.
But so many times we, who are doing okay and doing well, we forget some of the circumstances that some other people are in. And that is exactly what happened to that young man. He did not have the documents, and then he had to have his mother to try to help him, and she was having health issues. We tend to just forget everybody is not as blessed as maybe you are, you know. And I think we just don't show the compassion and the empathy in those cases.
I very much agree with that. And, some people, would say, well, look, if they can't do that, then they ought not vote. Even some black people say that.
Right,
Okay. And like you said, lacking empathy, lacking compassion. But the opponents of our voting rights, they know that these laws will affect black voters particularly.
right,
And they don't need a whole lot of black voters to be affected. They just need a certain percentage.
right,
And with a certain percentage being affected, that's enough for them to win elections, because a lot of these GOP folks know if a lot of folks go vote, they lose.
Let me ask you this, and you may not, I don't know if you had the opportunity to listen to the oral argument, but I believe I heard someone say that the attorney that was arguing for the GOP in this case before the Supreme Court, he pretty much admitted that, that this will help our team. You know, if we can have some impact on um, people not voting, it's gonna help us. And I'm thinking, it's just amazing. It's just amazing to me how blatant this stuff is in
Well, but
2021.
But why wouldn't he feel okay admitting that when six of the members of the court are his buddies and
Right.
compatriots, and they're all a part of the Federalist Society, and and and
And they've been working on this, from what I understand. When I have these discussions with you, they have been working on this for years. This
for
just didn't pop
years.
out the sky. They have been
Well,
working on this
well,
for
well,
decades.
not just years, yeah, decades. I mean,
Right.
this has been in place since the country's founding. And like I
Right.
said earlier, when our ancestors were finally liberated from enslavement, um, they immediately had to put the 15th Amendment in place. Well, first of all, 13th Amendment abolished slavery, like I explained. 14th gave us citizenship. And then the 15th Amendment and equal protection and due process. And then the 15th Amendment had to be added so that we could get the right to vote, but they still fought it. They
Right.
continued to fight it, and they fight it to this day. So
Right.
why wouldn't the lawyer feel very comfortable, the GOP lawyer feel very comfortable standing there and saying, yes, yeah, we don't want a lot of people voting because y'all know we're all a part of the
Right.
same clubs. Y'all know it's our strategy to keep people
Right.
from voting. So give us a case. Now that we got six of you all on this court, give us a case that will help us keep folks from voting.
Right. So now, in the interest of time, because
Yes.
I think
It's been a
have you?
minute. It's been an hour and 14 minutes. So we do need to bring this to a close.
Yes, I know you could go on and on and on. You
Yes, I could.
people, audience, he loves this.
Yes.
He loves studying the law. So we could go on and on, but we know we don't want to overload you with too much information. So you said some of what Justice Alito said. Anything else you want to add real quickly, or did you want to add some more of what Justice Kagan said in her dissenting opinion?
Well, she just said so much. Um, she said so much. Her dissent is should be required reading for anyone interested in this topic, and every black person should be interested in this topic. Now, it's legal writing, so it's not it's not easy to understand. You can read it and think you know what you're reading, but this is hard stuff, and you need the tools and skills and so forth to understand what it's saying. But she said a lot of good stuff. For example, um, she said, start with the majority's first ideal. A mere inconvenience, she quotes them, exception to Section 2. Voting, the majority says, imposes a set of usual burdens. Some time, some travel, some rule compliance, and all of that is beneath the notice of Section 2, even if those burdens fall highly unequal on members of different races. But that categorical exclusion for seemingly small or unusual or unserious burdens is nowhere in the provision's text. To the contrary, and as this court has recognized before, Section 2 allows no safe harbors for election rules resulting in disparate voting opportunities. This
Point
is what
blank.
she
She's
wrote.
saying,
Point blank.
okay,
Point blank. No small
right.
burden no small. Section 2 doesn't allow small burdens. It doesn't allow small disparities. If it results in, okay, based on the circumstances, if it results in
Yes.
not all members of a minority group having equal access or the voting process being equally open to members of a protected class, it violates Section 2, period.
Right. So Rule
Regardless of how
11,
big the disparity, regardless of how big the burden.
right.
Those are just factors that our opponents will use to further and continue disenfranchising us. Now, in the interest of time, let me say this. What can be done?
Right.
What can be done?
That was one of my questions. What is the solution?
The solution, as I see it at this point, the only solution at this point, is the passage of the John Lewis Voters Advancement Act. But in order to get that law passed, and also the For the People's Act, that needs to be passed as well, because then that will trump, for lack of a better word and no pun intended, that will trump a lot of these voter suppression laws. And getting the John Lewis Voters Advancement Act passed will reestablish some pre-clearance rules. Okay? But the
Okay.
problem is, in order to get those passed, since the Senate is 50-50, in order to get those passed, the filibuster rule has to be abolished. That's it. That's where we are. It
Right.
has to be abolished. I know it's scary to think of abolishing the filibuster rule, because there's coming a day when Republicans are going to control the White House and they're going to be in control. And then if the Democrats don't have the ability to filibuster, God knows what the GOP could pass along the lines of
Right.
race. I mean, they could do anything, right?
Right. Right.
And the same is true with the Democrats, because I'm not a Democrat. I'm not a
Right.
Republican. I'm neither of
Right.
those. So you do need some breaks, some way to stop some sort of runaway Congress from doing crazy stuff.
Right.
But voting rights are so critical to African Americans that if it takes abolishing, or maybe even at least tweaking the filibuster rule, that is where we are. And to me, that is the only way that we can undo what has been done. The only other thing is to add more people to the U.S. Supreme Court.
Yes, I've heard them talk about that as an option too. But
Yes.
we want something done. Do you think with them passing this law last week, is it going to have an immediate impact, or is it going to be more incremental and we'll see the negative consequences later on?
I think the impact will be immediate in those elections that are coming up in states that have these voter suppression laws. All right? Because now they got the green light. Your law is okay. All right? So whatever restrictive suppression laws that are in place, and if an election is coming up in one of those states, there is basically now very little way to challenge it. So in those states, in those elections, the results of this opinion will be felt immediately. But there will certainly be big time consequences coming down the road. For example, we got 2022 coming up, right?
Right.
We got 2024 not far from now, where we'll be back into another presidential election.
Right.
And with this case now out there having kicked the last leg of the Voting Rights Act, the GOP will do everything it can to pass even more restrictive laws. And without a filibuster rule in the U.S. Senate, without abolishing the filibuster rule, Democrats would not be able to pretty much do anything to stop it. I mean,
Okay, let me ask you.
it's like us being on a train, and and a train is coming right at us. That's the way I see this. This big, huge train is coming right at us, and they're pretty much in much of anything that we can do unless we're prepared to go nuclear and get rid of the filibuster rule.
Well, in addition to that, I would also think that a solution would be for us to really increase our organizing, and our advocacy, and getting people made aware of this. That's one of the reasons you're doing this video, is to sound the alarm. We have also got to, if it's protesting, if it's marching, if it's organizing our communities, our neighborhoods, our family, our friends, to make sure that we can do whatever we can to overcome the restrictions that they are going to put in place, and the restrictions that are already in place, along, in my opinion, along with what Congress needs to do. To me, it needs to be both and the legislative measurement as well as organizing amongst ourselves.
Well, I'm certainly not going to say anything against organizing, because it's very important, and protesting, all of that needs to be done. But I'm here to tell you, with this case out there, okay, with the highest court in the land having said the things that they said, having done the things they've done to Section 2 of the Voting Rights Act, that law was put in place to protect our rights to vote. That law now has been gutted. It is dead. It is essentially a dead law. And so all the marching and all the protesting is great. It's good to keep attention and focus on this matter, Tony. But with this opinion out there now, these states can pass nearly any law that they want. And if they pass a law, for example, the Department of Justice just sued the state of Georgia, right? Under Section 2, okay? And they wrote their complaint up in a way that still should survive this opinion.
That's what I was going to ask you. That was going to be my last question. How would this impact the DOJ, who has filed a lawsuit against the state of Georgia for their restrictive voting laws?
Right. So I haven't read the complaint, the DOJ complaint, but I've read some commentary, and it appears that the Department of Justice wrote up the complaint in a way that they're going to try to prove that Georgia's voting laws, restrictive voting laws, failed the intent test. In other words, they were intending to disenfranchise black voters.
Okay.
Okay? Excuse me. So that will survive what was handed down in this opinion. Because again, Section 2 still lives. It's just that Justice Alito took a stick or a hammer and broke that last leg of the Voting Rights Act in about 5 places. And so the whole thing now is basically wobbling. It's like, for lack of a better description, it's like a 90-year-old man trying to produce a baby.
Okay.
Yeah, I just thought about Abraham. Okay.
Okay.
You know, he was 100 years old, and with God's help, he was able to produce Isaac. All right. So think of the Voting Rights Act in that same impotent position. So the marching is good. I'm not discouraging it. The protesting is good. I'm not discouraging it. And yes, we got to continue to fight. We can't give up. We can't throw up our hands and say the fight is over. You're right. We keep fighting. We keep fighting. I guess what I'm trying to say is it's time to go nuclear. It is time to do something with the filibuster. That's what I'm saying.
And that's their job. I mean, that's Congress's job. You know, I think about so many times, you know, I work on a job. What if I didn't do what they hired me to do? I would be gone. So to me, Congress is neglecting their duties if they do not take this very seriously and make sure they enact something to counteract what came down the pipe last week.
And in order to do that, they've got to be able to overcome the GOP filibuster that is right now keeping the John Lewis Voter Advancement Act and the For the People Act from becoming law. There's no other way to get around it than to do something with the filibuster rule. Okay. All right. Now, that said, we are right at an hour and a half. This went a little longer. It could have went much longer, had much more to say. You don't cover 85 pages of such a critical civil rights opinion in such a short period of time. But we tried to give you all a little bit to water your taste buds and to open up your understanding. And hopefully, as Tony said, to get you angry, to get you protesting, to get you marching, to get you doing what we got to do, organizing to fight back. We can't give up. We can't throw up our hands. We've got to say to our elected officials, basically do something with that filibuster rule or increase the number of folks on the Supreme Court. Do something, because you cannot stand idly by and watch us get disenfranchised and take us back to Jim Crow. And I am not over-speaking when I say that is what is at risk here. Okay.
Well, I want to say I really appreciate the information that you have shared with us, the insight, the legal analysis, just helping us lay people who are not trained lawyers to understand what's going on. I hope our audience can appreciate it, and I know you will continue to educate us and help us know what we need to do in order to keep our voting rights intact. So thank you so much.
Thank you. And let me just say before we leave one last thing. Let me connect this with critical race theory. Okay? Critical race theory is all up in this because one of the complaints of critical race theory is how the law, although it's supposed to be race neutral and colorblind, still ends up disadvantaging Black Americans.
Right.
Okay? So although we got the 13th Amendment, the 14th Amendment, the 15th Amendment, although we got the Civil Rights Act, the Voting Rights Act, all this, we still end up in these deleterious positions despite the fact that the law is supposed to be racially neutral.
Right.
And that is what critical race theorists, and I am one, I am a critical race theorist where the law is concerned. because I see this every day. I see where these so-called race neutral laws still ends up disadvantaging black people, because oftentimes the people passing the law and the people interpreting the law are not black, and they
Right.
don't see it from our perspective, and we still get kicked upside the head.
Right.
So folks who are out there, including blacks, who are out there disparaging critical race theory and not knowing what you're talking about, you really need to be quiet and go study and learn why it is this kind of thing right here, this case right here, that critical race theory attempts to bring attention to and change.
Right.
Okay?
And we did 2 videos on critical race theory, so people can go out there and see those videos on YouTube or on your Facebook page, and learn more about that if they don't know about critical race theory. But you'll be coming back. You couldn't say
Yes.
everything tonight. You'll be coming back. You have this podcast, so you all stay tuned. Follow Augustus Corbett, Reverend Pastor Corbett, Attorney Corbett, activist, author. Follow him, and you will learn. You
But
will
most,
definitely
but
learn.
most of all, of course, a Christ follower, and second of all, the proud, godly, proud husband of Tony Corbett,
Well, thank you. Thank you.
and the godly, proud, and happy father of Chloe and Caleb Corbett. So that all that other stuff, that's good, but following him and loving you two, you three, that's what it's all about. So anyway, we're out of here. God bless y'all. Stay in tune. I mean, get woke. Okay, I don't care what folks, get woke. We're in serious days here, politically.
Very serious times.
Very
Yes.
serious. Okay, so that said, we're out. Love you, Tony.
Love you. Thank you.
Thank you for sitting in. Bye.
Bye.